Contract law is an important area of law, and it's something that we deal with in everyday life also. Although a contract, in order to be binding, must have a number of essential elements, it's actually very easy to form a binding contract in a common law jurisdiction. Contracts are governed by common law, and the law of contracts has developed over hundreds of years. In common law jurisdictions, the law of contract is very similar. So as we've seen already, the common law is very similar in countries that share a legal heritage with English law. So common law will be very similar in Ireland and in India, in Australia and in the United States. So we're going to look at the essential elements of a contract, and these are the offer, the acceptance, and the consideration. We're also going to look at how terms might be incorporated into a contract, and we're going to look at some of the constraints states put on our ability to form contracts. And then we're also going to deal with the issue of how we contract with people at a distance. This is very relevant in the internet age. So this is a pretty good definition of a contract. It's a spoken or written agreement that is intended to be enforceable by law. Spoken agreements are equally binding, and that's something that not everyone is fully aware of. Loose talk can bind you in a common law jurisdiction. It's important for a contract that the parties intended to be bound. But of course it's impossible to know what's inside someone's mind. So we look at the evidence, we look at the person's actions, we think about what a reasonable person might assume was their intent. So in a common law jurisdiction, there are a number of elements that must be present for a contract to be formed and to be legally binding. For there to be a binding contract, there must be an offer, there must be an acceptance of that offer, and then there must be some consideration from both parties. So an offer is when one party, we'll call the offerer, promises the other party, the offeree, something in return for something else. The offerer must specify what it is what he wants in return. So I could say, I will offer you €2,000 if you give me your car. That's an offer. An acceptance occurs when the offeree agrees to give the offerer what he asked for. So I might say, yes, I like that price. I will give you my car in exchange for that money. Consideration is what each party brings to the table. So on this contract, one person is bringing a car and one person is bringing money. Each party has some consideration here. All of these elements must be present for a contract to be formed. If any one of them is absent, there is no contract. Let's take a look now at some of the issues surrounding the offer. A promise is a commitment to do something, but it's just a promise. It's not a contract. A promise is not legally binding. So if I said to you, I will bake a cake for your birthday, well, that's a promise. If I don't bake the cake, I may be morally obligated to do something, but it's not a contract. It's not legally binding. A promise can be converted into an offer if something is requested in exchange. So I might say, I'll bake a cake for your birthday if you invite me to your party. There I'm promising to do something in exchange for something else. Once an offer is made, it remains open for a reasonable time. Now, what's considered reasonable will depend on the circumstances. an offer can be revoked any time before acceptance. But once it's accepted, there's a contract formed, and that's binding on both parties. But if you make an offer, you can revoke it any time before acceptance. Some of the issues surrounding the offer were considered in Dixon v. Dodds in 1876. In this case, Dodds offered to sell his house to Dixon and promised to keep the offer open until Friday. But on Thursday, Dodds accepted an offer from someone else to purchase the house. Dodds asked a friend to tell Dickinson that the offer was withdrawn. On hearing this, Dickinson went to Dodds' house first thing on Friday morning to accept the offer that he had been made. When Dodds told him he was too late, Dickinson brought an action seeking to enforce the contract he believed that had been formed. The court found that Dodds had indeed made an offer to Dickinson, but that the additional promise to keep the offer open was just that, a promise. It was only a promise. And that the offer to sell the house and the promise to keep the offer open were distinct. If no consideration is given for a promise, then it's not enforceable. It's just a promise. The court also found that Dickinson had been given acceptable notice that the offer had been revoked. Even though it was via a friend, he had been told that the offer had been withdrawn. For an offer to be valid, it must be shown that the offerer intended to be bound by it. So if I was to say, if you come to class on time, I will give you €1,000,000, although the words I'm saying sound like an offer, no reasonable person looking at that situation would think I was serious. No person looking at that would think I intended to be bound by that offer. Of course, no one is claiming to be able to look inside my mind, and that would not be a defence for me to use if it looked like I was making a serious offer. Harvey v. Facey is an important case from 1893 from Jamaica that ended up at the Privy Council in the UK. And this was a case involving an alleged contract that was formed by telegraph. I wasn't aware till I was reading this case that you could actually send a telegraph to someone while they were on the train and they would actually get it. So Harvey sent a telegram to Facey asking if he would sell a particular property in Kingston. And he was asked to say what his lowest price would be. Facey replied that the lowest price was £900. Harvey replied saying, "We agreed to buy Bumper Hall Pen for the sum of £900 asked by you." However, the Privy Council held that there was no contract formed. Facey had not directly replied to the question that asked would he sell. The lowest price stated was merely responding to a request for information. It wasn't an offer to sell. There was no evidence from Facey's telegram that it was intended to be an offer. Perhaps the most interesting case involving contract law, and one that's beloved by law lecturers the world over, is Carlisle v. Carbolic Smoke Ball Company. The Carbolic Smoke Ball Company sold a product that stopped people from getting the flu, allegedly. And this is an ad that it put in the newspaper telling people about the product and also telling them that they would give £100 reward to anybody who used the product as directed but still got the flu. Carlisle purchased the ball and used it as directed, but still, no surprise to us in modern times, contracted the flu anyway. Carlyle sued for the £100 reward. The Carbolic Smoke Ball Company argued that the ad was not a serious offer. It was not intended to be an offer, and it was just sales puff. The company also pointed out that Carlyle did not accept the offer, and it received no notification of such an acceptance. The Carbolic Smoke Ball Company also argued that it was not possible to make an offer to the whole world. The court disagreed and found that the advertisement was not just sales puff, and that it was intended to be taken seriously. It found that the deposit of £1,000 in the Alliance Bank demonstrated that this was an offer that was intended to be taken seriously. In general, however, the courts have found that an advertisement is not an offer to sell a product. If it were an offer, then a shop might be required to sell more products than it has in stock. If my advertisement is an offer to sell a product, and I get 1,000 acceptances of that offer, I would be required to meet my contractual obligations and sell 1,000 TVs. I might not have them. So the courts have ruled that an advertisement is an invitation to treat. It's simply inviting offers. So when a customer buys a product, they're offering to buy it, and the vendor agrees to sell it. The most widely cited case to demonstrate this is the Pharmaceutical Society of Great Britain versus Boots. The way we shop now is very different from in the past. Nowadays we're used to walking into the shop, strolling around at our leisure, perhaps with a basket in hand, looking at the different products, examining them, comparing them, then choosing what we want, putting it into the basket and walking to the counter to pay. In the past, and before Boots introduced this system, you would walk into the shop and the goods would be behind the counter. You would speak to the sales assistant, maybe figure out what it is you wanted, what it was the most appropriate product for you, and then pay for it there. In the UK, at the time Boots introduced this scheme, the law required that pharmaceutical products were sold only in the presence of a pharmacist. The Pharmaceutical Society of Great Britain brought an action on foot of this. It probably turned out that Boots was able to have fewer pharmacists in the shop than it had before. In any event, the court needed to determine whether Boots was offering products for sale in the absence of a pharmacist. So the court needed to decide exactly at what point the contract was formed. The court decided that the display of goods on the shelf was not an offer. It was just an invitation to treat. It was an invitation to make an offer to purchase. The court ruled that when a customer takes the goods to the till, the customer is making an offer to purchase the products, and then the shop assistant accepts that offer. So the customer makes the offer and the shop accepts. That being the case, then, the contract is formed at the till in the presence of the pharmacist. There's an Irish case which came to a very similar conclusion about who's the offerer and who's the offeree, which part of the transaction is the offer and which part is the acceptance. So in this case, a coat was displayed on a shop window with a price to be paid in cash, but also a weekly credit price. We used to call this buying something on the Never Never in Ireland a long time ago. At that time, It was an offence to offer goods for sale on credit terms without specifying the full terms. This was in order to protect consumers. The Minister for Industry and Commerce brought an action against the shop for making an offer without the terms being fully available. However, the court ruled that the display of the coat on the window was not an offer to sell it. It was simply an invitation to treat. So anyone purchasing the coat was going into the shop and offering to buy it, and then the shop was accepting that offer. As a general rule then, an advertisement is not an offer to sell. It's merely an invitation to treat. It's inviting potential customers to come and make an offer to purchase. This, of course, has implications for online selling. And one of the things in Amazon's terms and conditions sets out very, very precisely when an offer is being made, who is making the offer, and when it is being accepted. It's tempting to think that when you go to Amazon, Amazon is offering to sell you something, and when you click and add it to the shopping cart and pay, you're accepting Amazon's offer. But of course, as we've seen from these cases, that's not the case at all. As we would expect, an e-commerce website is just an invitation to treat. And actually what's happening is when we go to buy something, we are offering to purchase it, and then the retailer is accepting the offer. Or not. Let's look closely at what Amazon's terms and conditions has to say about that. So your order is an offer to Amazon to buy the products in your order. So Amazon isn't offering to sell, you are offering to buy from Amazon. So you are the offerer and Amazon is the offeree. When you place an order to purchase a product from Amazon, we will send a message confirming receipt of your order. The order confirmation does not confirm acceptance of your offer to buy the products. So you are the offerer, you are offering to buy, but when we send that email confirmation, that's not our acceptance. We only accept your offer and conclude the contract of sale for a product ordered by you when we dispatch the product to you and send an email or post. So Amazon is saying that when you come to our website, we're not offering anything. You are offering to purchase. The email you get from us is not an acceptance. We only accept your offer when we ship it. So we have in a nutshell there in that short paragraph the conclusion of all of those cases that we looked at. Let's look now at some of the issues around the acceptance of an offer. Acceptance occurs when the offeree agrees to give the offerer what he asked for. Now, a very important point is that there's no special form of acceptance required. There's no need for a signature or a handshake or sealing wax. The offeree merely has to indicate that he accepts the offer. There are some constraints, however. The acceptance must match the terms of the offer exactly. A counteroffer does not constitute an acceptance. So, suppose Mr. Brown offers to sell his car for €2,100. And Mr. Green says, call it 2,000 and it's a deal. Is there a deal? Is that a contract? Are the parties bound? Well, no. Mr. Green has not accepted Mr. Brown's offer to sell the car. He has made a counter offer to buy the car. So now Mr. Green is no longer the offeree, he is the offerer. He is offering to give €2,000 in exchange for the car. And now Mr. Brown is the offeree. He can accept the offer or not. If he accepts the offer, then they have a binding contract. An important point, however, is that once Mr. Green made a counter-offer, he became the offerer and Mr. Brown became the offeree. Mr. Brown's original offer no longer exists. This precise issue came up in 1840 in Hyde v. Wrench. So Mr. Wrench offered to sell his farm for £1,200. Mr. Hyde did not take up that offer. Subsequently, Mr. Wrench offered to sell his farm for £1,000. Mr. Hyde came back with an offer to buy the farm for £950. When he didn't hear back from Mr. Wrench, he contacted him to accept his offer to sell the farm for £1,000. When Wrench didn't sell the farm, Hyde went to court to enforce the contract he believed they had. However, the court ruled that there was no contract. It found that Mr. Hyde's counter-offer destroyed Wrench's original offer to sell for £1,000. So all we have here is an offer from Hyde to Wrench to buy the farm for £950, but there was no acceptance from Wrench in this case. Wrench's original offer to sell for £1,000 was destroyed, so it was no longer available to Hyde to accept that. There are in fact two ways for an offeree to accept an offer. If I said to you, I will sell you my car for €3,000, you could say back, I will buy it for that price. So now we have a contract. We have both promised something to the other, and those promises bind us in a contract. This is known as a bilateral contract. It's two promises. However, there's another way you could accept. If I said to you, I will sell you my car for €3,000, you could just throw €3,000 on the table. I would take that as an acceptance. You don't need to promise the thing I'm asking for. You can just give it to me. This is known as acceptance by performance. So sometimes the offerer wants the offeree to perform some action specified in the offer. It's not necessary for the offeree to promise to perform the action in order to accept the offer. Performance of the action specified itself constitutes acceptance. So this is known as a unilateral contract. So it's not two promises, it's a promise and an action. Suppose I said, if you come to class in costume on Halloween, I promise to give you pizza. You could say, that's a great idea. I promise to come in costume on that day. So now we have a binding contract. We have each made promises. We are bound by those promises. So you have to come to class in costume that day, and I have to give you pizza. However, suppose I said to you, if you come to class in costume on Halloween, I promise to give you pizza, and you say nothing. You could just turn up in costume on the day, and then I would be bound by my offer, which I have not revoked, to give you the the pizza. So you can accept my offer by performance of the action I have asked for. You don't need to promise to do the thing, you can just do it. And this is precisely what Carlyle did in the Carbolic Smoke Ball case. The Carbolic Smoke Ball company argued that the offer that it had made had not been accepted. No notice of acceptance was given. But the court found that not only was the advertisement a genuine offer, but that this was a unilateral contract. And in unilateral contracts, there's no requirement that the offeree communicates an intention to accept. Acceptance can be through full performance of the thing that is asked for. So suppose Mr. Brown said to Mr. Black, "I'm going on holidays next week. I will give you €300 to paint my house while I'm gone." Mr. Black can say, "I accept your offer." And so Mr. Brown can go on holidays and Mr. Black can paint the house. And when he comes back from his holidays, they're both happy because everybody did what they promised they would do. However, suppose that Mr. Brown says, once again, "I'm going on holidays next week and I will give you €300 to paint my house while I'm gone." And Mr. Black says nothing. Now, while Mr. Brown is on holidays, Mr. Black isn't especially busy, so he decides that he will paint Mr. Brown's house. So he paints it. And when Mr. Brown comes back from holidays, he sees that the house has been painted. Should he be happy? Should he be prepared to pay the money? Well, yes. He made an offer to Mr. Black. The offer was not revoked at any time, so the offer was still valid. And Mr. Black accepted that offer when he painted the house. So in painting the house, Mr. Black accepted Mr. Brown's offer. They had a contract and he should be paid. But of course, it is open to Mr. Brown to withdraw the offer any time before it's accepted. So imagine again, Mr. Brown made the same offer. "I'll give you €300 to paint my house while I'm gone." He goes on holidays. Mr. Black comes along. Mr. Black hasn't said he would paint the house. He hasn't accepted the offer. And Mr. Brown then sends a message to Mr. Black saying he's changed his mind. He doesn't want his house painted. He's revoking the offer. Suppose then that Mr. Black paints the house anyway. When Mr. Brown comes back, should he be happy? Should he pay? Did they have a contract? Well, no. It was open to Mr. Brown to withdraw the offer any time before it was accepted. Revoking offers that can be accepted by performance, though, can be a bit tricky. Suppose once more that Mr. Brown offers Mr. Black €300 to paint his house while he's on holidays. And once again, Mr. Black says nothing. Mr. Brown still has no idea whether Mr. Black is going to accept the offer or not. Mr. Black then decides to paint the house, but before he's finished, he gets a text from Mr. Brown saying that he's changed his mind, he doesn't want the house painted, and he's revoking his offer. Where do the two parties stand now? That's a tough one. Revoking an offer that can be accepted by performance before the performance has been completed, but after it has started, can be difficult. So in some cases, the offer cannot be revoked. It's too late to withdraw the offer. Similarly, if acceptance has been made by full performance, then of course it's just too late altogether to withdraw the offer. Where an offer can be accepted by promise or by performance, the offeree may choose which way to do it. Let's take a look now at some of the issues around consideration. Consideration is what each party brings to the transaction. In the case of selling a car, Mr. Brown is bringing the car and Mr. Green is bringing the cash. But there must be consideration from both parties if there is to be a contract. For a contract to be formed, the consideration must be sufficient. But that's different from it being adequate. So I can agree to give you my BMW in exchange for your bicycle. My consideration is the BMW, your consideration is the bicycle. It's arguable that that's not a great deal. But the law isn't there to protect people or to stop people from making bad deals. That's their choice. As long as the consideration is sufficient, we have a contract and that binds us. Let's take a look now at how the terms of a contract may be incorporated into the contract. This can be a big deal. So the terms of the contract must be available at the time that the contract is made. If an offer is made and there are certain terms that the offeree doesn't have access to, then it's not possible for those terms to form part of a valid contract. Furthermore, for the contract to be binding, the offeree must be in a position not to accept. One of the problems that the law has, however, is that some contracts have a great many terms and conditions and people don't read them. This has come up in a number of cases where people get tickets for travel and the ticket says that there are terms and conditions attached to the contract. But those terms and conditions don't fit on the ticket. They're somewhere else to be found. And so this is quite a complex area of law. While it is still the offeree's responsibility to check the terms and conditions before accepting a contract, the offerer does have some responsibilities also. Any unusual or especially onerous terms must be highlighted. This came up in a case involving a car park where a man was injured and there were terms and conditions associated with the use of the car park, and the ticket he got from the ticket machine told him there were terms and conditions but didn't tell him what those terms were. The issue of incorporation of terms into a contract is especially relevant today when we have websites and apps that have really long lists of terms and conditions that no one actually reads. When software used to be distributed on physical media like floppy disks or CDs or DVDs, software firms sought to bind purchasers of the product with shrink wrap contracts. The physical package would be sealed, and a notice on the front of the package would say that by opening this package you agree to the terms and conditions, whatever they might be. A more modern incarnation of a shrink wrap contract is a click wrap contract. In these contracts, the offeree is asked to check a box in order to signify that he is agreeing to the terms and conditions. This is very common in apps and also on some websites. A web wrap contract takes this to another level. In these contracts, the user of a website is told that by continuing to use this site, you are agreeing to blah blah blah, whatever the terms and conditions might be. the jury is still pretty much out on how much a person can be bound by terms and conditions in these circumstances. But certainly, as long as an offeree is made aware of terms and conditions, and those terms and conditions are available for the offeree to check, it really is the offeree's responsibility to read them before accepting the offer. Sometimes there might be something missing from a contract. This can happen for a number of reasons. It could be that the scenario that comes up isn't something that the parties to the contract had imagined would ever happen. It could be that they imagined it happening but thought that the contract covered it. Or it could be something that they couldn't agree on and so deliberately left it out. It can happen that the courts are asked to imply terms in a contract, but they're typically quite reluctant to do so. Various tests have been developed by courts over the years. The most well-known test is the officious bystander test. In this scenario, the court imagines that the two parties are about to make the contract, the offer has been made, it's about to be accepted, and a third party who is not involved overhears this and says, "Don't you mean to include these terms also?" And if both parties reply, "But of course," and if both parties would reply, "But of course," then those terms were intended to be included in the contract. Those terms were implied. Another test is that the terms should go without saying. And yet another is that they would be necessary to give business efficacy. The issue of implied terms in contracts is quite complex, but we should at least be aware that it is an issue. So where we have an offer and an acceptance and consideration from both parties, we can have a contract that legally binds both of them. It's very easy to form a binding contract, and the state typically doesn't interfere with people's ability to do that. However, there are certain scenarios where the state has an interest in constraining or regulating the formation of contracts. So throughout history and from place to place, states have seen fit to regulate certain kinds of contracts by preventing them from being formed in the first place, or by putting requirements in place as to the form of the contract. In Ireland, for example, gambling contracts are unenforceable. If you make a bet with someone and they don't pay up, you can't take them to court. Gambling contracts cannot be enforced. Similarly, insofar as an agreement to marry someone might be considered a contract, that can't be enforced and you can't recover any kind of damages for breach of that contract. If you agree to marry someone in Ireland and you change your mind, they can't sue you, no matter how much the restaurant or the hotel or the dress cost. There may also be limits on a person's capacity to form a contract. Children, for example, cannot make contracts. So a child can make an offer, you can accept it, there can be consideration from both parties, but there is no contract. Children can't make contracts. Similarly, people with diminished mental capacity may not be able to enter into enforceable contracts. There's also an issue surrounding the influence of drink and alcohol and drugs. I mean, if you are drunk and you make an offer and someone accepts it and there's consideration from both parties, are you bound by that contract? I mean, that's a tricky one. You might argue that if it was obvious from the situation that you were very drunk, then that might render the contract unenforceable. But if it wasn't obvious, and to anyone observing the situation it appeared to be a serious offer, then you may well be bound. It shocks many people just how easy it is to form a legally binding contract. If two people make an agreement and they have a binding contract, there can be difficulties if one of them doesn't want to fulfill his obligations. In 1677 in England, the Statute of Frauds was introduced. And this was a law governing certain kinds of contracts. The purpose of this was to make it harder for people to enter into very serious contracts, and also to make it harder for them to get out of them once they had been formed. So it required that certain kinds of contracts had to be evidenced in writing and be signed by the parties to the contract. And this served a few purposes. The first was to prevent fraud or perjury. So before the Statute of Frauds, a party could go to court and say, we had a contract. I offered this, he accepted it, and now he's trying to welch on the deal. And the courts might have had difficulty determining who was telling the truth. The Statute of Frauds also had a cautionary effect. Loose talk could land you in the midst of a legally binding contract, whereas the act of having to sign a piece of paper might give a party pause for thought. The Statute of Frauds also served an evidentiary purpose. If there was a dispute over precisely what it was the parties had agreed, well, by having it evidenced in writing, it was there for all to see. So the Statute of Frauds required that certain contracts had to be evidenced in writing. Some of these contracts included agreements for the sale of land, agreements that can't be performed within a year, agreements to act as a guarantor for someone else's debt, agreements for sale of goods greater than £10. No, I'm not sure what £10 would have bought you in 1677, but it was probably quite a lot. And wills for estates of greater than £30. Various common law jurisdictions then passed their own statutes of fraud. The England and Wales statute was actually replaced over time, and it's arguable that it has no current effects whatsoever. In Ireland, the Statute of Frauds was passed in 1695. Now, much of it has been replaced, so when you're buying a house, for example, that's covered by the Conveyancing Acts. But in Ireland, more of it remains in force than perhaps in many other jurisdictions. So a lot of the Statute of Frauds is still with us. Individual US states each have their own Statute of Frauds as well. However, even where the Statute of Frauds has been repealed or replaced, it still survives in spirit. And there's very much an expectation that certain kinds of contracts would be evidenced in writing and signed by the parties. Let's consider now some of the issues associated with contracting at a distance. Where both parties are in the same room, it's very easy for them to form a contract, and it's very easy to tell when the offer was made and when it was accepted. But if the parties are not in the same place when the contract is formed, it may not be clear precisely when it is formed. Now, this can actually make quite a difference. In contract law, there's a long-standing postal rule. In contract law, there's a long-standing postal rule. When someone sends a letter, it doesn't arrive instantly, of course. When parties agree to contract by post, an offer is made as soon as it is received by the offeree. So, if, say, an insurance company sends a letter to your house offering to insure your home, and it takes 1, 2, 3, 4 days to get there, well, then the offer is made when you receive it on that 4th day. According to the postal rule, a contract is formed as soon as the acceptance is sent in the post by the offeree. So if you accept the insurance company's offer to insure your home and you put it in the post and it takes 1, 2, 3, 4 days to get to the insurance company, the contract was actually formed when you put it in the mail. Now, the date an offer is made typically isn't that important, but the date that the offer is accepted and the contract formed can be very important. Imagine if, after you posted the letter, your house burned down, but the letter didn't arrive until after that. Would the insurance company be bound by the contract that you had? Well, because the contract was formed when it was posted, they would. Now, the postal rule only applies where both parties have agreed to form the contract by post. And it can also be quite easily sidestepped, actually, if the offerer phrases the offer in quite the right way. But the default setting is that the offer is made when it's received by the offeree and accepted when it is sent by the offeree to the offerer in the post, irrespective of when it arrives. So your house burning down after you've posted the insurance policy is an example of when the time a contract is formed may be very important. But the instant in time when the contract is formed may also give an indication of the place where the contract was formed, and that can also be quite important. In this Irish case before the Supreme Court, the postal rule not only informed when the contract was formed, but as a consequence of that, where it was formed. So a contract was signed and posted from Dublin to Oslo. It turned out then that subsequently the offeree had an accident and there were issues over compensation for injuries. The plaintiff Kelly wanted to sue for compensation in Ireland, but the defendant argued that the case should be heard in Norway and that the contract was made in Norway, so it should be adjudicated there. However, the Supreme Court ruled that the contract was in fact formed when it was posted in Dublin, and therefore it was formed in Ireland. But the postal rule is actually a bit of an anomaly. Where other kinds of technology are used to contract at a distance, the scenario may be quite different. An important English case on this issue was N. Torres v. Miles Far East. So Entoris was a London-based company, and it sent an offer by Telex to purchase copper cathodes from Miles Far East Corporation in Amsterdam. The Dutch company also accepted the offer by Telex. Now, when the contract wasn't fulfilled, Entoris wanted to sue, but the issue arose as to where the contract was formed, and so in which jurisdiction the case should be heard. The Court of Appeal ruled that the regular postal rule doesn't apply to instantaneous forms of communication. It ruled that acceptance occurs when the message of acceptance is read, and so the contract is made where the message of acceptance is read. So in this case, the contract was formed when Entoris received the message of acceptance from Miles Far East. It's worth reading some of the judgment in the case. When a contract is made by post, it is clear law throughout the common law countries that the acceptance is complete as soon as the letter is put into the postbox, and that it is the place where the contract is made. But there is no clear rule about contracts made by telephone or by telex. Communications by these means are virtually instantaneous and stand on a different footing. Suppose, for instance, that I shout an offer to a man across a river or a courtyard, but I do not hear his reply because it is drowned by an aircraft flying overhead. There is no contract at that moment. If he wishes to make a contract, he must wait till the aircraft is gone and then shout back his acceptance so that I can hear what he says. Not until I have his answer am I bound. The contract is only complete when the acceptance is received by the offerer, and the contract is made at the place where the acceptance is received. So Denning is saying here that yes, the postal rule is all very well, and we could take the postal rule and apply that to modern day technologies, but he chooses not to do that, and he's saying that what sets modern communications apart is that the technology allows for almost instantaneous communication. What then about email? Is email more like the post in that it's asynchronous, or is it more like telex or telephone, which is almost instantaneous? The computer scientist in me wants to say that email is asynchronous and it's just like the post. But I wonder, do non-IT people think about minutes as being a long time in the same way we do? For many users, email seems instant, but when you understand how email works, you realize that it's not quite. And of course, what's the situation with emails that are sitting there waiting to be read? They've arrived, but haven't been read. Where do we stand with those? This is perhaps less of a problem in 2017 when people get their emails on their phone. But for many people, work email is still only something they see at work. There was a 2010 judgment which dealt with precisely this issue. So in this case, the contract was being completed by email. And it was pretty much a done deal on a Friday evening. However, the situation changed and one of the parties wanted to back out. And the question arose, when was the contract actually formed? Had the contract already been formed and was it binding? Or was the acceptance still in the ether, so to speak, and not yet the basis for a concluded contract? The judgment, as you would expect, considered both the postal rule and in Torres v. Miles Far East Corp. It's very long and very detailed, but it is worth our attention. The general rule is that the acceptance of an offer is not effective until communicated to the offerer. The postal rule is an anomalous exception to the general rule, which is limited to its particular circumstances. It does not apply to acceptances made by some instantaneous mode of communication. This was decided in Torres v. Miles Far East, as regards communications by telex. At page 334, Denning said that in such a case, the contract is only complete when the acceptance is received by the offerer. Contrary to the claimant's submissions, in my view, the same principle applies to communication by email, at least where the parties are conducting the matter by email, as the solicitors were in this case. However, that does not conclude the question, because issues may remain as to when the email in question was received, and also whether it was received. As Lord Wilberforce put it in Brinkebon v. Stahagstalen, when the condition of simultaneity is met, and where it appears to be within the mutual intention of the parties that contractual exchanges would take place in this way, I would think it a sound rule, but not necessarily a universal rule. The senders and recipients may not be the principals to the contemplated contract. They may be servants or agents with limited authority. The message may not reach, or be intended to reach, the designated recipient immediately. Messages may be sent out of office hours or at night with the intention or upon the assumption that they will be read at a later time. There may be some error or default at the recipient's end which prevents the receipt at the time contemplated and believed in by the sender. The message may have been sent and or received through machines operated by third persons, and many other variations may occur. Similar issues arise when the medium of communication is by email. In Brinkebon, Lord Wilberforce's conclusion was that no universal rule can cover all such cases. They must be resolved by reference to the intentions of the parties, by sound business practice, and in some cases by a judgment where the risks should lie. In Bernouth Lines Limited v. High Seas Shipping, it was held that notice of arbitration was validly served by email, notwithstanding that it may not have reached the relevant managerial or legal staff in the recipient company. Clark said, "That is not to say that clicking on the send icon automatically amounts to good service. The email must, of course, be dispatched to what is, in fact, the email address of the intended recipient. It must not be rejected by the system. If the sender does not require confirmation of receipt, he may not be able to show that the receipt has occurred. There may be circumstances where, for instance, there are several email addresses for a number of different divisions in the same company, possibly in different countries, where dispatch to a particular email address is not effective service. However, the judge noted in this case that these particular considerations do not apply. It is not in dispute that the email was received in Mr. Cusack's mailbox at or close to 1800 on the 24th of August, and was available to be read by him. So that's important there. It was available to be read by him. The question is whether the defendants are correct in their submission that acceptance was not effective from the moment the email was received because it was sent after working hours. In those circumstances, it is submitted relying on the passage in Lord Wilberforce's judgment that I've quoted, acceptance by the 1800 email could not in any event have been effective until it came to Mr. Cusack's eye on Tuesday morning. But he went on. Once one sets aside the postal rule as inapplicable to email communications, the question whether an email acceptance is effective when it arrives, or at the time when the offerer could reasonably expect it to have read it, is not a straightforward one, and does not appear to be settled by authority. On the basis that it must be resolved by reference to the intentions of the parties, by sound business practice, and in some cases a judgment where the risk should lie, the answer does, however, appear to me to be clear in the present case. In the context in which the 1800 email was sent, that is, a transaction which could have been completed that evening, I do not consider that 1800 was outside working hours. The email was available to be read within working hours, despite the fact that Mr. Cusack had in fact gone home. For that reason, I would have held that were the defendants to have accepted the Rickaby's undertaking by Mr. Dew's email, then as a matter of law, such acceptance would have been effective upon the receipt of the email at or about 1800. So this judgment is saying that where an acceptance by email arrives at a reasonable time, the acceptance occurs at that time, even if the email itself is not read till later. It's not clear what would happen if the email arrived after office hours. And clearly email is a bit problematic. Clearly email is a bit problematic, and there may be some uncertainty as to whether contracts formed by email are binding. In the interests of efficiency and legal certainty, most states have addressed this issue directly. In Ireland, this question is addressed in the Electronic Commerce Act. Section 19 of the Act quite clearly states that electronic contracts are still binding. This also applies to a contract that might have fell within the domain of the Statute of Frauds. So any contract shall not be denied legal effect solely on the grounds that it is in electronic form. No, in a Statute of Frauds scenario, okay, you still have the unresolved question of how do you do a signature, if a signature is required. But a contract will not be rendered invalid solely because it's an electronic one. And in Section 19, Part 2, it's saying that the offer, acceptance, cancellation, and revocation can all be electronic. So people are free to make contracts using electronic means, and those contracts will be as binding as paper contracts. Now, the question of where and when acceptance may occur is still a tricky one. So Section 21 of the Electronic Commerce Act tries to address this. It says where an electronic communication enters an information system, it is taken to have been sent when it enters such information system. So when you send an email and you put it into the system, that's when it is deemed to have been sent. Section 21 continues, where the addressee of an electronic communication has designated an information system for the purpose of receiving electronic communications, then the electronic communication is taken to have been received when it enters the information system. So if I have agreed with you that we are going to form a contract by email, your acceptance will be deemed to have been received when your acceptance enters the email system, irrespective of when it arrives, irrespective of when I get it. But that's only if I have agreed that with you. Where the addressee of an electronic communication has not designated an information system, the electronic communication is taken to have been received when it comes to the attention of the addressee. So if we haven't agreed this, or if I haven't agreed this with you in advance, then your acceptance of my offer, for example, would only be binding on me once I have received it. So if I make you an offer by telephone, for example, and you accept by email, I won't have entered into a binding contract with you until I get the email. So you could see how you might send it on a Friday and I might not get it till a Monday. Well, then the contract is formed on Monday. But if we go back to the previous situation where I've designated email, well, then your acceptance will bind me in that contract once you send it, once it enters the email system at your end. And Section 21 goes on to point out that all of this applies irrespective of where we are, irrespective of where the sender or the receiver are. Now, the issue of where a contract is formed and therefore where it would be adjudicated in the event of a dispute is a tricky one. And it's especially problematic in the EU, where the single market is such an important feature and the EU wants that market to function smoothly. So the Rome I regulation, as it's known, tries to provide clarity on which member states' laws will apply when a contract has an international dimension. And so parties are free to specify in the contract which laws will apply. This is actually quite a common practice globally, where say in a big deal with companies from many countries, they might specify that in the event of a dispute, the contract will be adjudicated in England. That's actually quite a common choice of jurisdiction, and many practitioners in London do quite well out of that. Thank you very much. So Article 3 of the Rome I regulation says that the parties can choose in the contract which one country's laws will apply in the event of a dispute. However, if the parties haven't chosen a country and put it into the contract, there are some default rules. So a contract for the sale of goods shall be governed by the law of the country where the seller has his habitual residence. So if in Torres v Miles Far East was heard today, that case would be heard in the Netherlands under Dutch law. A contract for the provision of service shall be governed by the law of the country where the service provider has his habitual residence. Quite sensibly enough, a contract for the sale of goods by auction shall be governed by the law of the country where the auction takes place. However, Article 6 recognises that individual consumers within the EU are actually in quite a weak position. So a contract concluded by a natural person for a purpose outside his trade or profession, with a person acting in the exercise of his trade or profession, shall be governed by the law of the country where the consumer has his habitual residence. So if I'm an individual consumer contracting with a business and I have a problem, the case is decided where I am. But for the most part, as a rule of thumb, a business selling goods and services can expect to be sued in their home. And that degree of certainty makes it easier for people to do business. At least they know where the case is going to be adjudicated, and I guess if they have issues with that, maybe they can decide in the contract before they conclude it. And as a rule, an individual customer has the right to sue at home. Interestingly, in September 2017, Ryanair had an issue with its staff where their employment contracts stated that they were contracts in Ireland and that the contract was formed in Ireland and would be adjudicated in Ireland. But some employees in Belgium took a case to the European Court of Justice, and the European Court of Justice ruled differently. So even though the contracts had been formed in Ireland and the contract stated that, it decided that individual employees were not unlike consumers in that they were in a slightly weaker position and that they had the right to sue in their home. Let's take a closer look now at the issue of signatures. In certain circumstances, there may be a requirement for a contract to be signed. So we saw that in the Statute of Frauds, for example, it had to be evidenced in writing and signed by the parties to the agreement. There are certain things you can't do just in a conversation. There are certain things that are so serious that there are formalities associated with that. In the Land and Conveyancing Reform Act, for example, we see the inheritance from the Statute of Frauds. In Section 51 of that Act, it says that no action shall be brought to enforce any contract for the sale or other disposition of lands unless the agreement on which such action is brought, or some memorandum or note of it, is in writing and signed by the person against whom the action is brought or that person's authorised agent. So here we have a 2009 incarnation of those requirements from the Statute of Frauds. So if you want to sell land in Ireland, the agreement must be in writing and must be signed. But in the internet age, what constitutes a signature? The traditional form of a signature is written by hand, typically in ink on a paper document. But other forms of signature have been recognised by the courts too. And it's important to realise that in a common law jurisdiction, the courts are actually quite flexible about the form of a signature. We've all had situations too where someone has sent us a document like a PDF and they say, can you return that to me signed? And you're like, so I have to print it, sign it with a pen, and then scan it and send you back another PDF? It's a pain. So maybe next time you can tell them, well, actually, I'm going to sign it a different way, and in the jurisdiction I'm in, the courts are fine with that. If we think about the job a signature is doing, it typically performs three functions. First of all, it identifies the person signing the document. So often someone might be in the habit of signing their signature and then writing their name underneath so that it can be read, because sometimes a handwritten signature can't actually identify the person that's doing the signing. It also evidences intention to sign. So when you're signing a document, you're making a conscious decision to do that signing. And it's also evidence of intent to adopt the content of the thing that you're signing. So it's an employment contract. It signifies your intention to take up the job. So it says who you are, that you're signing, and this is what you're signing. It connects those three pieces of information. But what actually constitutes a signature in the law? Like I said, we're familiar with the handwritten signature on paper in ink. But what else counts as a signature? Well, it turns out that in Ireland, quite a lot actually. So Clark states in his Contract Law in Ireland book that signature has been interpreted very loosely, and it has been held that a rubber stamp, typed words, or an illiterate's mark may suffice. In Godley v. Power, in a case involving property, so that would have been covered under the Statute of Frauds, the judge said that a memorandum must contain all essential terms. The parties, the property, and the consideration must always be ascertainable from it. But it didn't say anything about the specific form that these things must take. In Bacon v. Kavanagh in 1908, the court found that "you" was actually sufficient to identify one of the parties because it was clear from the document to whom it referred. And in Guardian Builders v. Kelly, the judge pointed out that the test is whether the parties can be readily identifiable. So the signature and the memorandum for a statute of frauds type scenario doesn't necessarily have to actually have the person's name, as long as the person can be readily identified. In an important Irish case, the issue came up as to what constitutes a signature on a transaction for property again. And in this case, the solicitor involved was getting the secretary to type a letter, and she had started on plain paper, and he made a point of saying to her, "No, I want that to be done on headed note paper from the firm of solicitors." And the Supreme Court ruled that the name of the solicitors on the headed note paper could actually constitute a signature for the purposes of the statute. But if we ask the same question then in the era of email, it becomes kind of tricky. So in this English case that dealt with that issue, Meza v. Pereira Fernandez, Mr. Meza sent an email containing a guarantee, and because he was guaranteeing the debt of another, that was a statute of frauds type scenario. Now, he didn't type his name at the end of the email. However, his email address was automatically inserted into the email header, so it was possible to identify that it was him. But the court decided that this was not a signature. And the main issue here was that the header was added automatically by the email client. He didn't put it there himself, so it didn't count as a signature. This is perhaps what might distinguish this case from the previous one, where the solicitor did make a point of using the headed note paper. That was a choice he made, whereas Meza did not choose the email header. In a similar case sometime after, Tankship 2 v. Gwangju Bank, Gwangju Bank Limited did not appear in the text of the body of the guarantee that was sent. However, the message was sent using SWIFT, which is a secure messaging system that banks use. And the judge found that in this case, sending the message by SWIFT was so secure that it was the equivalent of a signature. And it was within the spirit of the statute of frauds. So this is what distinguishes this from the Meza v. Pereira Fernandez case. So it's clear from those cases that not only are the courts prepared to accept that a contract can be formed by email, but even the special kinds of contracts that fall within the requirements of the statute of frauds or similar requirements can also be met by email. This is an interesting case, however, because the court found that a chain of emails containing all of the operative terms could also satisfy the requirements of the statutes of frauds. So all of the relevant pieces of information were not in a single email, they were in a chain of emails. But even that chain of emails constituted a memorandum that was evidenced in writing. Interestingly, also in this case, signing off an email with just Guy was sufficient to meet the requirements for the signature, because it was clear who Guy was, and it was clear that he put it there himself and that he intended it as a signature. So let's recap then. It's very easy in a common law jurisdiction to form a contract. The law is very flexible as to the form of a contract, and there are few requirements or restrictions placed on people's ability to form contracts, and contracts can be formed just by speaking, talking, email, telex, fax, text message, whatever. However, the formation of a contract requires three essential elements. There must be an offer, there must be an acceptance of that offer, and there must be consideration from both parties. A contract that doesn't bind both parties binds neither. For certain kinds of contracts, very serious business, things that you would have to think about, the law requires that the contract be evidenced in writing and that it be signed by the parties. However, in such scenarios, the law is quite flexible as to the form of the memorandum that is evidenced in writing and also to the form of the signature. So it is possible to conduct quite serious business by email or by other electronic means. There may be scenarios where there is confusion as to when the acceptance happened and so when the contract was formed. And that's especially complex when it comes to asynchronous forms of communication, contracting at a distance, or other electronic means. In Ireland, there's both Irish legislation and EU regulations that try to remove some of that ambiguity and put some legal certainty into the mix. And so contract law is a very good example of how the common law can actually expand and stretch itself a bit in order to accommodate new situations, new scenarios, new ways of doing business, new technologies for communicating. But we still always have to go back to the main principles, where you have the offer, the acceptance, and the consideration. You must have all three. If one of these is absent, there is no contract and no one is bound.